Good afternoon. In this video, I will be discussing about parental and quasi-parental act. Like in the previous video, I have covered the topic judicial and quasi-judicial act. But in this video, I will be covering parental and quasi-parental authority or act, you can say. So, as per the Hindu law, the father and mother are the natural guardians of children. Guardian is a person who take care of minor and his property from birth of a child. Parent acquire the rights and duty of a guardian by natural relationship. So it is a duty of natural guardian to maintain the child. So there's a equality of rights for both the parents in respect of the child, custody, education, control, correction, upbringing, everything. So child future is in the hands of the parents. So there are like various restraints that need to be followed as per the necessities of the society for this, and parents, they're given authority to control and correct them by either kind of force, and such people are protected under the law of torts and only if the act is reasonable manner and for a good cause. So it is deemed to be have reasonable by the judges or jury changes as per the time, or either there's no exact manner defined. So rights which are there under the parental authority, like various rights and duties which are under parental authority. First one is right to custody. When we talk about right to custody, it is of two types. First is legal, in which there is right to make a decision for the child, and another is physical, which means the right and duty to provide housing and care to child. Next is right to education. It is the duty and right of natural guardians to provide the necessary education of the child and help in making his future bright. Then right to control. The parents can also restrict the movement of the minor of the minor child if they find out it like it is unfit for him, and can also take action against him in a moderate manner. Right of supervision. The parents have the right to supervise and advise their children in life so they can do the right thing. Then right to protection and health care. The parents have the right and duty to protect their children from anything harmful, and to provide basic health care. Then right to reasonable chastisement, and which literally means a severe criticism or a punishment. The parents have the right to punish the child in a reasonable and moderate manner when we talk about. So quasi parental authority, the you know sorry under the quasi parental authority, the term Latin term loco parentis, which means the place of parents. The people in loco parentis are called quasi parents, and however quasi parental authority come with the less rights and duties than parental authority. Parents are not in charge and tend to delegate the authority to someone else who can take care of the child. For instance, in school, the parents delegate the authority to children and to teachers and principal, and they can take the decision of the child. However, the law is that the parents and quasi parents they both can administer punishment on the child for his good, or to prevent him from hurting himself or any other person. So they have a lawful control over the children, can correct him at every point. So parents may also delegate their authority to babysitter, and who has a particular time period over care of the child, and she act as a quasi parent. So similarly, when the child is in the school, and parents are deemed to delegate the responsibility to the teachers. Position under the England and India. In England, a parent or quasi parent who has the lawful control or charge of a minor can correct the child, and has the right to administer and punishment on the child as per the Child and Young Person Act 1933. So there was this case, Cherry versus Booth, in which the defendant was a school headmaster. Two boys fought on the way to school, and defendant administered punishment on them, and the head minister was held liable for the assault and battery. And however, it was held that he was not liable as an authority of teachers. It is only limited to school premises, but also outside the school. So as per the injury, there is not much opportunity for a boy to exhibit his moral conduct while his school is under the eyes of law, eyes of master, and the opportunities while he is at the play outside the school. So it is obvious that at home the parents have the control of children, and at the school the teachers are and the principal. But the main question is, who is in charge between the school and house? It can be rightly said that the authorities delegate to the teachers, so they cannot only correct that for their wrongs, but also administer punishment upon them. So hence it is above that boys fought out of the school, and had minister had the authority to punish them. So in another case, Isel versus Board of Education, a student threatened counselors to commit suicide, and but they failed to inform the parents. This negligence by not providing knowledge to parents was a loophole, and since the school was in authority to control the child, it should have been informed the parents about the threat as said by the Maryland High Court, and hence, as per the law in England, in authority of schoolmaster is same as that of the parents, and they represent the matters in matter of correction as held in Regina versus Hopley. So in India, it has been held over time. The teacher plays a very important role in student life. It has been well recognized over the year, like the quasi parental authority of teacher come with the inherent try to take disciplinary action against the pupil, and have been ingrained in the country's philosophy as which was said in R.C. Thampam and others versus Principal Medical College. Okay. So in Lakshmi Kant Shripant Bhantra versus C.R. Gernard, it was held that schoolmaster was power of chastisement and uh, over a pupil committed to his charge arising from the delegation by parent or guardian. So the position of right of teacher has been explained in the case of Sakuni versus Swamitha Pathar by Venkata Subha Rao. And he said the teacher cannot get away with the punishment with an excuse that the punishment has left no mark on the body in one or other. If punishment could have caused harm to life and limb of the child, and the teacher will be accused under the law of torts. However, in the above case, like two smacks were given by the defendant and was held liable to violent and considered reasonable. So I would like to conclude that it is clear that parental and quasi-parental authority come up with a certain rights and duties which need to be performed in the welfare of the child to ensure there is a good upbringing of the child. With these rights come the responsibility to show the child right path, has to correct either words or it could be in a moderate manner, but this can't excuse to skip the criminal or civil liability like assault, battery, etc. The test of reasonability depends upon the court, and the punishment administered should be of such a nature that prudent man would have been considered right. Thank you.